morning. We're here this morning to hear oral arguments in the case. It's Richard Auth versus Industrial Physical Capability Services, Inc. Each party will have 15 minutes to argue their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and I will keep you advised in the passage of time. We're being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read the briefs and we're ready to proceed with you are.
Good afternoon. May it please the court, my name is TJ Evans, and I, along with my co-counsel David Lewis, represent Industrial Physical Capability Services Incorporated, or IPCS, and reserve 5 minutes for rebuttal. The underlying lawsuit was brought by a minority shareholder, Richard Auth, against IPCS and its majority shareholder, Dr. Gilliam. There are only 2 shareholders of IPCS, and Dr. Gilliam is the majority shareholder, the founder, the president, and the only person responsible for handling IPCS's day-to-day operations since its inception in 1998. As such, Dr. Gilliam and IPCS's interests are aligned. We're here today on an interlocutory appeal of a discovery order, where the court stated that Mr. Auth is entitled to all discovery submitted to the court for in-camera inspection, which consisted of Krugliak's litigation file, and to other discovery consistent with the court's order. But the lower court erred by finding that IPCS and Dr. Gilliam do not have a mutuality of interest. The lower court's order departs from well-established law, strips IPCS of its right to counsel, and eviscerates the privilege. Because the attorney-client privilege is eviscerated, we respectfully request that this court reverse the lower court's determination for 3 reasons. First, IPCS did not waive the attorney-client privilege. Second, the shareholder fiduciary exception does not apply. And third, the crime-fraud exception does not apply. As a brief background, IPCS provides physical capability testing to assist companies in evaluating employees returning to work from an injury and new hires. IPCS uses a proprietary mathematical model developed by Dr. Gilliam prior to IPCS being incorporated. Coupled with the fact that Dr. Gilliam is the only person responsible for handling IPCS's day-to-day operations, and as recognized by the lower court, it makes sense that Dr. Gilliam is the one who guides the corporation and communicates with corporate counsel. Which brings me to my first point. IPCS did not waive the attorney-client privilege. It is well established under Ohio law that the holder of the attorney-client privilege is the client, and only the client can invoke or waive the attorney-client privilege. The lower court's order erred by finding that Dr. Gilliam is a third party, and communications from Krugliak to Dr. Gilliam waive the attorney-client privilege. As mentioned, Dr. Gilliam is the majority shareholder, he's the president, he's the founder, and he's the only person responsible for the day-to-day operations. Clearly, he is not a third party, and finding a waiver is not supported by the law or by the facts. What the lower court appeared to do in trying to level the playing field was find that the shareholder fiduciary exception applied to the incident facts. However, as a threshold matter, the court must find that Mr. Auth and IPCS have a mutuality of interest. As conceded by Mr. Auth in his deposition, which is in the record as document 93, he conceded that the adversary relationship against IPCS began as early as May 2014. At that time, Dr. Gilliam, on behalf of IPCS, retained Krugliak to evaluate the threats made by Mr. Auth's personal counsel and to negotiate a buyout. During that time that Krugliak was investigating the facts, it determined that Mr. Auth had secreted communications with IPCS's prior counsel, which was McDonald Hopkins, and IPCS has asserted a separate action against McDonald Hopkins, which is currently pending before Summit County and stayed pending determination of this action. The exception does not apply once there is a sufficient adversarial relationship and upon the anticipation of litigation. As early as May 2014, Mr. Auth has engaged counsel and threatened lawsuits against the corporation. Accordingly, the shareholder fiduciary exception does not apply. Additionally, Mr. Auth cannot show good cause for the information he seeks. Throughout the briefing, Mr. Auth has claimed that he's only seeking historical, factual information. That historical factual information is discoverable through the actual parties, through IPCS's prior counsel, through Mr. Sharp, through McDonald Hopkins, or through additional depositions of Dr. Gilliam. There's simply no need to invade the attorney-client privilege. Accordingly, we don't find that the shareholder fiduciary exception is applied, and we're asking that the court reverse the lower court's determination that the shareholder fiduciary exception applied. And finally, the crime fraud exception here does not apply. Mr. Auth must present evidence sufficient for a finding of probable cause that Krugliak actively facilitated or concealed a crime or a fraud. Based on the record before this court, there is simply no evidence for this court to make a determination that the crime fraud exception applies. There was no hearing before the lower court, no documentary evidence was submitted, no testimony was taken, no affidavits were submitted. Simply based on the record before this court, it should find that the crime fraud exception does not apply. And procedurally, the crime fraud argument may not be properly considered on appeal because the court expressly stated it is not necessary for the court to determination whether the crime fraud exception applies to the present case. Because when the crime fraud exception applies, it only allows the disclosure of communications directly related to the crime or fraud. The lower court would need to make a determination as to which documents actually were based on facilitating or concealing a crime or fraud. So accordingly, because the lower court's order erroneously determined that IPCS waived the privilege and that the shareholder fiduciary exception applies, this court should reverse the lower court's ruling and affirm it as with respect to the crime fraud exception, finding that it's not applicable here. I'd like to reserve the remaining time for rebuttal unless there's any questions.
Counselor, I think it was represented in some case law in opposing counsel's brief that in terms of the crime fraud exception, there are courts that have considered a breach of fiduciary duty rather than what we think of as a crime or a fraud. Do you have any comment on that?
Yes.
Assuming that it were right to handle here.
Yeah, assuming that it were right, Your Honor, some courts in Ohio have considered a breach of fiduciary sufficient to trigger the crime fraud exception. In those cases, there are some element of a crime or a fraud. I believe in Euclid Retirement Village, the court found that a breach of fiduciary was sufficient to trigger the crime fraud exception, but there was evidence of fraud or evidence of self-dealing. Here we have no such allegations. The pleadings simply do not plead with particularity any type of fraud or any type of crime that was facilitated upon this court, and specifically none that Krugliak helped conceal or facilitate.
Thank you.
Thank you.
So we have 7 minutes and 44 seconds remaining.
Good afternoon, Your Honors. I'm Louise Mazer. I represent Richard Auth. He's the appellee on the main appeal and the cross appellant on the appeal that he has brought. I'd like to first thank this panel for the special session. I know that we're cutting into your lunch. It's as though we're talking about two different cases when I hear what my opposing counsel has to say. As I view the very succinct issue when you put aside the posturing of the parties is this. Can a small, closely held corporation, by its controlling shareholder, invoke the attorney-client privilege and work product doctrine to hide evidence that the controlling shareholder has breached his fiduciary duties and likely is committing fraud? I believe that that is the issue before the court. I urge this court to affirm the judgment of the trial court that held that selected portions of the Krugliak file were discoverable on the basis of waiver, and we also ask this court, pursuant to Appellate Rule 3C on our cross appeal, to uphold that the discoverability of these selected portions of the record are proper pursuant to the crime, fraud, and fiduciary shareholder exceptions. I do want to spend a little bit of time, I know Your Honors have reviewed the briefs, but to highlight the most salient portions, because, Your Honor Callahan, I do believe that the fact that there has been claims of fiduciary duty is critical in this court's determination, both on the crime fraud exception and the fiduciary duty obligations that Mr. Gilliam has breached. also goes to the waiver because, as we know, the lower court determined that there is no mutuality of interest between IPCS and Tom Gilliam because of the positions that he asserted. Tom Gilliam was involved in 3 other companies, each of which did this exact same testing, and for each of these 3 companies, he created this proprietary mathematical formula that they used. In none of these other companies did he ever claim to receive any royalties, nor did he receive any royalties. And as a matter of fact, he ended up being in litigation with his 3rd employer, Disability Management, who claimed that he had actually taken the formula and used it inappropriately. What we do know is this: the history leading up to this dispute between Auth and Gilliam is nearly irrefutable. Tom Gilliam formed IPCS in 1998. He testified that he created a mathematical formula for IPCS to use in its physical capability evaluations, and that IPCS consistently used that formula in its business from 1998 until June of 2014. Up until the time that Krugliak's attorneys were retained in this case, Tom Gilliam represented to the world that IPCS owned this formula and had every right to use it. First in the marketing materials, and I will quote, the IPCS technology, the IPCS, quote, proprietary mathematical model, quote, IPCS proprietary formula. And my personal favorite, quote, IPCS has created a proprietary mathematical model to calculate the IPCS score. Tom Gilliam admitted during his deposition that all of the literature that contained these words were approved by him, and when pushed, he admitted that these statements were inaccurate and they were a play on words. But it doesn't stop there. We had a memorandum offering in 2009 that was sent out by IPCS, again approved by Tom Gilliam. Never did he represent in that memorandum offering that IPCS didn't have the ownership of the technology or even the right to use it. Now imagine what investor would want to invest in IPCS if they knew that IPCS didn't have the ability to conduct the very business that their money was being solicited for. The provider agreements contain similar representations that the formula is owned by IPCS. And last and certainly not least, the immediate prior attorneys for IPCS were retained by Tom Gilliam to try to protect this formula that IPCS had been using. Attorney David Kupar from the McDonald's Hopkins law firm testified that Tom Gilliam and Tom Gilliam alone was his primary contact with IPCS, and that based upon everything that Tom Gilliam told him, he believed, as the attorney, that IPCS owned the formula and had every right to use it. These kind of representations were consistent with what Gilliam told Auth at that point in time when IPCS was on the brink of bankruptcy, and because of their friendship, these men were friends, Gilliam convinced Auth to loan money and invest into the company. Auth believed that IPCS owned and had the right to use this formula as represented in all these other documents. In 2013, these gentlemen decided that Auth would begin working for IPCS in January of 2014. He quit his job in December of 2013 in anticipating of starting to work there. Unfortunately, he was diagnosed with cancer in January, and because of his treatment, could not start until sometime in late spring. At that point, he approached Tom Gilliam again, saying, I'm ready to work, and was told, no, that's going to happen, not going to happen. And that's when, for the first time, Tom Gilliam said, by the way, IPCS doesn't have the right to use this formula. I own it. It is at this point that the dispute arose between Mr. Auth and Mr. Gilliam. It is at this time that Mr. Auth raised for the first time Tom Gilliam's inappropriate use of company funds to pay himself and his family members exorbitant salaries and raises, and use company funds to pay for things like Giant Eagle grocery bills, landscaping at his home, and his family's personal vacations. What's interesting is what Tom Gilliam said during his deposition when asked, why the change in June of 2014 when the office of Krugliak was first retained? And he said this, quote, "It wasn't until this litigation took place that it came to my attention that that issue was never discussed or resolved. So it wasn't until 2014 that I realized I own this technology. I own this proprietary mathematical model." Think about it. This is the fellow who created the formula, who operated IPCS for, I'm not sure the math, 18 years. He found out through some catharsis in June of 2014, IPCS doesn't own this formula. But it gets even better, because all the while, after Krugliak was retained, and by the way, let's make clear for the record what IPCS says in its brief. Quote, "Krugliak has represented IPCS based upon factual information given to it." Quote, "When IPCS retained Krugliak, Krugliak sought to discover the historical facts from both shareholders about the ownership of the IP. Krugliak's attorneys were charged as the company attorney, as Switzerland, to go and uncover facts regarding the technology ownership issue. Krugliak's attorneys were in privity with both attorneys, my client, a 45% shareholder, who, by the way, is also one of 2 directors. All the while these factual investigations were being conducted, unbeknownst to Mr. Auth, Gilliam formed secretly a company, TB Gilliam LLC. And at the very time where there was a shareholders and directors meeting in December of 2014, apparently Krugliak's attorney were drafting a technology license agreement that was signed by Tom Gilliam, despite his conflict of interest, by IPCS and this newly formed company, TB Gilliam LLC. The contents? Despite the very strong disagreement between Gilliam and Auth on the technology ownership issue, this technology license agreement had IPCS agree that it didn't own the technology and it never had the right to use it. This technology license agreement that Tom Gilliam signed for both companies gave his newly formed company the right to receive royalties in the future, but also past due royalties of $980,000. Think about that. Nearly $1 million. Now this all took place before this litigation was filed. And during that meeting, that shareholder meeting in December of 2014, these facts were not revealed to us. Even after the litigation was filed, it was not until after Auth filed a motion to compel that the technology license agreement was first produced. And in fact, there's a pleading where the Krugliak office had to retract prior statements indicating that no such technology license agreement existed. What we do know, what you do have in the record, and I urge your honors to look at the records and the different documents that are attached to the pleadings. IPCS paid in royalty nearly $200,000 from January of 2015 through September of 2015. And what you'll also see if you look in the record, that money was used to pay Tom Gilliam's private attorney in this litigation. These are the facts against which this court is being asked to decide whether or not the select file materials are discoverable by Auth pursuant to waiver, the shareholder fiduciary exception, and the prime property exception. I think that the lower court was on all fours when the judge decided that waiver applied, and these are the reasons. As the court noted, and it's ironic because I'm the only one that hasn't seen these documents, so I'm kind of going in the blind here by what I see in the record. Most of the communications do not deal with legal opinions, they deal with factual matters. That's not surprising because Krugliak admits they were retained to investigate facts. Secondly, even though it's clear that Tom Gilliam has an adversarial relationship to IPCS, all of these documents were freely shared with him and his private attorney. It was for this reason that Judge Parker determined that waiver applied, because it was disingenuous for IPCS to argue that there was no mutuality of interest between it and Auth, who was advocating the point that IPCS owned this technology and can use it, and in the same breath say that there was mutuality of interest between IPCS and Gilliam, even though Gilliam was trying to take this IP for himself. It's for these same reasons that the shareholder fiduciary exception applies. As is noted by the Gardner case, there's a balancing test to be applied, whereas here, there has been a claim by a minority shareholder that there's been a breach of fiduciary duty. It's a balancing test, and if you look through all the factors in Gardner's, I think they all weigh in favor of Auth. He is one of two shareholders. He owns 45% of the shares. By the way, that means he's paying 45% of the fees of the corporate attorney in this case, right? Is the claim colorable? I think it is, because for 18, 19 years, you have a person who represented to the world that IPCS owned and could use this technology, and only changed his mind after Auth questioned, why are you spending the corporate money the way you are? The Euclid retirement case gives us some guidance, even though it's in a partnership setting. Whereas here, you have two business owners, the company attorney isn't privy. Krugliak's attorneys should have been like Switzerland. They should have gone out, investigated the facts, and then given the facts to both shareholders and both shareholders' attorneys. That's not what happened here. And I believe that in large part is the reason why the lower court determined that there was a waiver. I want to also stress to the panel some inaccuracies. Auth is not trying to get the litigation filed with Krugliak. Please go through the privilege log and please go through the notice that Auth supplied. What we're trying to find are what appear to be factual communications regarding the Auth-Gilliam matters in dispute. Nothing more, nothing less. We're not trying to get litigation strategy. We're not trying to get attorney work product after this litigation was filed. There are, and I counted them, 23 instances after this case was filed on January 23rd, 2015, where communications were highlighted only because third parties were involved in those communications, and again, primarily Gilliam's private counsel.
And with that, you've come to the end of your 15 minutes.
Thank you. For all of these reasons, Your Honor, I urge you to affirm the decision below and allow my client, Mr. Auth, to obtain the selected file materials from the Krugliak firm's file. Thank you very much.
There is certainly a lot to unpack here. First, I understand Ms. Mazur's position. She's absolutely aggressive for her client and certainly trying to increase the value of the corporation by seeing facts that are simply not there. Opposing counsel is attempting to mix ownership with use. IPCS has the right to use the proprietary mathematical model. It is in IPCS's best interest that it had the right to continue to use that mathematical formula. That's how it generates its revenue. This is simply a service company. And I understand that the lower court may have based its entire decision on the fact that in its belief that IPCS would be in an adverse position to Dr. Gilliam simply because it might be more valuable if it owns the IP. But simply put, IPCS has no more right to claim ownership to the proprietary mathematical model than it does the Taj Mahal. The facts simply do not support ownership. And secondly, there are legitimate business reasons why the corporation should not own the IP. For instance, IPCS provides services to railroads and to airlines with substantial amounts of revenues involved. And if there's a potential lawsuit against IPCS and there's a judgment obtained, that IP becomes available to a potential judgment creditor. And at that point, the company can no longer operate. However, if it's protected and Dr. Gilliam personally owns it, the corporation can live to fight another day and can continue to operate.
Or Dr. Gilliam could decide he wants to take it and leave, and how does that affect the company?
Which is even more significant on why there should be a technology licensing agreement in place for IPCS to be able to continue to use the IP.
And when did what type of licensing agreement come into fruition?
Well, Ms. Mazur did mention the December 2014 shareholders meeting. It was discussed, if that's in the record, the shareholders meeting transcript is document number 95. The licensing agreement was actually discussed at that meeting. It's in the best interest of the corporation to have that protected. And it was actually discussed. Krugliak did in fact draft a licensing agreement. Dr. Gilliam on his own behalf ultimately executed unbeknownst to IPCS, who ultimately did produce that document in discovery. And ultimately, Ms. Mazur points out that we were evaluating facts. Well, at this point, IPCS has disclosed close to 8,000 documents in discovery that contain factual information. We've turned over the entire McDonald Hopkins file. I would ask you to look at the privilege log. Certainly only a small portion of the documents have communications involving Dr. Gilliam's personal attorney. And we would claim that those are subject to the common interest privilege because there is a mutuality of interest involved between these two parties. The next point is Ms. Mazur points out a timing issue that only after Mr. Auth claimed was trying to buy out his shares, was trying to sell his shares, was trying to negotiate a buyout, only after that time did Dr. Gilliam claim that he personally owned it. That was the only time he needed to. There was no other attempts to ever have a buyout of the company from 1998 through 2010. Dr. Gilliam was the primary party involved in this case, was simply looking for the corporation's best interest, and the value of the corporation wasn't as significant. It was just basically having the IPCS produce as significant of revenues as possible. Dr. Gilliam wasn't looking for a buyout of his shares.
I don't want to, counsel, I'm sorry, I don't want to get into something that's not in the record.
Sure.
Sometimes just because I read it in the brief doesn't mean it's in the record, but there had been prior litigation Mr. Gilliam. Would not his ownership of that intellectual property have been important in those litigations?
Absolutely, Your Honor. And the result of the disability management case, which a member of Ross McDowell was involved in, so they're intimately familiar with this case, the ultimate end result was that Dr. Gilliam owned the IP. And this was prior to IPCS even being incorporated. And
when was that case resolved?
it was sometime prior to 1998. I'm sorry, I don't have that information in front of me, and I don't want to speculate.
So then why is it just coming to his attention in 2014 that he owns it?
Wasn't necessarily just coming to his attention, it was just becoming relevant in evaluating the corporation to evaluate the shares of Mr. Auth.
And that's all on the record?
The prior case is not on the record.
I think she asked you something that is not in the record. She doesn't want to hear about it, so that's why I'm just asking if this was not or it was in the record.
My apologies to the court, the prior case absolutely is not in the record.
I'm sorry, you may not have understood what she was asking you, but we have to be careful about that.
Absolutely, yeah, thank you for clarifying. Ms. Mazur also disputes that claims that there was a waiver involved here, but she simply did not dispute this court's precedent in Teodecki versus Litchfield Township, that's out of this case, where it stated that an attorney cannot waive the attorney-client privilege. Only the client can waive the privilege, and so Krugliak simply communicating with Dr. Gilliam is not sufficient to operate as a waiver. And additionally, regarding the crime-fraud exception, she did not dispute this court's precedent in 2014 in Lytle versus Matthew, where no witnesses were called at a hearing, no one was present or sworn in. Instead, all of the relevant information came through argumentation of a defendant's attorney. That is all we have here. If the court evaluates the record, there's simply no testimonial evidence, no documentary evidence sufficient to support a finding of the crime-fraud exception. I would also like to stress with this court, and although this is not the record and it was not cited in our brief, we did come across the law review that evaluates the shareholder fiduciary exception, and that's in 35 Cardozo L.
And it's not in your brief?
It's not in our brief, but it does.
Counsel, if it's not in your brief, I'm sorry, I don't mean to be giving you a hard time
Understood.
today. I just
Understood.
have to make sure that we all follow the same rules, that's all.
Absolutely. And
That's kind of why we're here.
it's simply illustrative of the fact that the shareholder fiduciary exception can ultimately swallow the rule of the attorney-client privilege, and why I would urge this court to find that the shareholder fiduciary exception does not apply. Otherwise, similar corporations, these closely held corporations, a minority shareholder simply has to create a breach of fiduciary duty claim to invade the privilege. And that's what we're trying to collect, and opposing counsel ignores the fact that Dr. Gillen can wear more than one hat. He can operate as the management of the corporation, and he can operate as the majority shareholder and have his own rights. For these reasons, we're respectfully requesting that the court reverse the lower court as it relates to the waiver and the shareholder fiduciary exception, and find that the crime fraud exception does not apply. If there's anything else.
Counsel, before you talk about the law review article, you mentioned a case, just clarify the case you mentioned.
I mentioned one for the waiver, which was Teodeki,
That was the
T-E-O,
one. That's
okay,
what I-
versus Litchfield, and that was, I don't have the year here in front of me.
But that's in your brief.
That's
Yeah.
the one I was looking at, thank you.
Yeah. And then, I also mentioned Lytle versus Matthew in the 9th District in 2014, and that is in the brief as well.
Thank you for your presentations here today. Court will take matters under advisement, issue a written decision will be mailed to both sides, as well as posted on our site and at the Supreme Court. With that, the court will be adjourned until Thursday.
Your Honor, may I beg the court's indulgence to clarify one thing? The issue on that prior lawsuit, if it's in the record or not, I can answer that if Your Honor would allow me.
Your time is
Thank
up,
you.
so we're going to stop it now. Thank you.
We don't concern you.